Hello, hello, hello. Good afternoon, everyone. How's everyone doing today? My name is Ifeoma Odunlami, for those who do not know me. And for those who are showing up to my live for the first time, let me know so I can say hello. And I want to introduce myself. My office is in New Jersey, but we serve clients in all 50 states. We're an immigration law firm, and that's all we do: immigration. We do family-based, and we do humanitarian. So if you join in, say hello. Thank you. Grace rated, first time. Well, welcome. I hope you get good value today. And in New Jersey, we've had quite a week. We had an earthquake on Friday. Did anybody experience it? I didn't. Not the first, not the aftershocks, because I was on the road. I was driving, so I don't know what it is about driving that I guess I didn't feel the earth rumble beneath me. But yeah, that was scary for, it was scary for a lot of my family and friends that I talked to. And yesterday was the eclipse, which was so beautiful. So yeah, it's been a eventful couple of days. So I have a really great topic. Lily Gabriels, you experienced it. Was it scary? Yeah, I heard it was. Yeah, good day. Yeah, good day, Lily. Nice to see you. Thank you for joining me. So anyway, guys, I have a great topic today, and you know, I get my topics from, I do consultations, and then things come to my mind, and I'm like, I need to let my immigrant family know about this because this might be helpful to them. So today I want to talk about waivers when people commit certain immigration crimes or break immigration laws, and they're unable to get their green card because they have to get forgiven for it. So, hi, Shorty, nice to meet you. So, I want to talk about that, and I want to give you guys some information that hopefully will help you. And every time I do my lives, right, I want to counteract the false information out there that I'm seeing. People are giving immigrants false information, and leading them on the wrong path. So with this lives, I want you to have some understanding about what the law is. Like, this is not, there's not attorney-client um, relationship, because I do not know you, I do not know your case, but this is generally what you need to know so that you have a better idea of what the situation could be. So, when intending immigrants file certain documents, they're looking to get a green card. So, when an officer denies them a green card or tells them they need a waiver, then what that means is that they need to get, I guess, forgiveness, pardon for whatever it is that was done. And until you get that, you cannot get that green card. So that's why it's really important. Waivers are really important. And to put together a good waiver case requires you to, basically get various information and put it together in a powerful package. So I want to talk to you about different scenarios where you would need a waiver. And then I want to talk to you about the ones I see in my office a lot, right? So if you are here in the United States unlawfully, which means you're not here on a visa, you came through the border without a visa, right? That's an unauthorized presence. Now, in certain situations, uh, staying here after your visa is expired is not a problem, such as if you're married to a U.S. citizen, or you're the parent of a U.S. citizen who's over the age of 21, and many humanitarian visas such as VAWA, U visa, T visa, asylum. It would not matter, but in certain situations, you actually do need to get forgiveness for being in the United States. So I'm going to talk about two cases that we actually got waivers approved recently so that I give you context to what I'm talking about. So we're going to discuss that later. So you can also need a waiver if you've been working on unauthorized employment and you don't qualify in a category that would forgive that without the formality of a waiver. So for instance, if you're married to a U.S. citizen, you're forgiven for having worked without papers, right? You're not forgiven if you pretended to be a U.S. citizen to work. False claims to citizenship is never forgiven. So you want to know that, okay? So if, say, you're an F1 student, right? You came in on a student visa, you're not supposed to work more than 20 hours in your school, and you did, and you're married to a green card holder, you've had on authorized employment, and you're going to need a waiver, right? Now, if you're married to a U.S. citizen, doesn't matter that you worked without authorization. Doesn't matter. Now, misrepresentation or fraud is a big one that I see in, cases being denied for a lot. So I'm going to talk about that quite a bit too. So if you came into the United States and you misrepresented a material fact, such as you lied about whether you were married, because a lot of people say they're married so that they give the illusion of ties to their country so that they can get a B1, B2, and then they're given a B1, B2, and then they come here, they meet somebody, they fall in love, they marry the person files for them, and then you go for the interview, and the officer is like, well, when you came here, you said you were, when you applied for your visa, you said you were married, so where's your divorce decree? And then some people compound that misrepresentation by getting a fake divorce decree. Please don't do that. Because in this day and age, it is very, very rare for immigration not to be able to find your footprints. In this day and age where, anything can be found, it's really hard to hide your footprints. So it's easier for you to get a waiver in that situation than to get a fake divorce decree. So don't compound a misrepresentation or fraud with an additional misrepresentation or fraud. So that's a misrepresentation or fraud. Some people come into the US with another person's passport, with somebody's passport and somebody's visa. That's a misrepresentation. That's fraud. Now, if it's a passport from any other country except for US, that could be forgiven with a waiver. However, if it's a US passport, if you came in with a US passport that's not yours, or you faked a US passport, there's no waiver for that. So, none. So, conviction of certain crimes. There's certain crimes that you may commit, like a theft here, whatever it is, you may have to file a waiver. Some crimes are forgivable, some are not. A lot of the drug crimes over 30 grams of marijuana are not, there's a waiver for them. So you want to know this. All right. Now, what else? Health. There are health reasons that you may need a waiver. You might, have one of those health conditions that make you inadmissible, in which case you need a waiver. All right. So those are some of the reasons why you would need a waiver. Now, the standard for a waiver is proving extreme hardship to a U.S. citizen, spouse, or parent, right? That's a typical waiver. Now, if you're in a situation where you're in deportation proceedings and you're seeking cancellation of removal, you can also seek a waiver with your child as a qualifying relative. But in most cases, right, except certain cases, your child cannot be a qualifying relative. So let me explain that. I'll break this down. For a lot of people who came through the border, right? So you're coming through the border, you were not inspected, you were not admitted, and you come in, and then you've been living in the United States all these years, you have American children, and one of them turns 21, and they can file for you. Well, they can file for you, the I-130 will be approved, but because you came in through the border, you were not inspected, you were not admitted, you're going to need a waiver, right? And unfortunately, in this situation, your child cannot be a qualifying relative for a waiver. So that application leaves you nowhere, at least you're stranded. You can't get a green card. Now, let's twist this a little and say that when you came in through the border, you weren't inspected, you weren't admitted, but you came in and you fell in love with a US citizen, right? Or a green card holder, right? And then they filed a petition for you, you needed to file a waiver, right, because of the manner of your entry. Now, you can file a waiver. You would have to file an I-601A waiver to waive your the manner of your entry, And so you would have to file the waiver, have the waiver approved here before you leave. And when the waiver is approved here in the United States, right, you can take the waiver approval and you have to go back to your country and go before the embassy and come back through consular processing, right? Now, if you have committed a crime, which this is really important, that's why it's so important to be honest with your lawyers. If you committed any kind of crime, right? Remember, there are different types of waivers. So if you're getting a waiver for unlawful presence, right? That's not a waiver for a crime. That's not a waiver for a misrepresentation, right? So if you have a waiver for unlawful presence and you take that waiver and you leave, but you didn't tell your lawyer that you had been convicted of a crime or you had committed a crime involving moral turpitude or anything like that, and then you go out and the officer, at the embassy interviews you, they realize that you have committed some kind of other crime that made you inadmissible, you're not going to be able to come back to the United States without filing another waiver to forgive that particular crime or immigration violation, because you didn't indicate at the time that was, that you had committed a crime. So it's important that your lawyer knows, if you're leaving the country, especially on a waiver, a 601A waiver, that they know if you've been convicted of any crime, because you want to make sure that you have the right waiver that allows you to come back. But for most people who their only issue is that they're unlawful presence, it's really not complicated. Once you get the waiver approved, you continue through the process, the NVC process and all that, and then when there's an interview date for you, you go back to your country, you get your interview, and you come back. Right? It happens. So people, don't be afraid of, if you have to do consular processing, don't be afraid of it. Of course, people don't generally want to leave, and that's okay if there's a way for you to stay here and adjust your status, right? Such as if you're a VAWA petitioner or U visa or T visa petitioner, it doesn't matter how you came into the country. It doesn't matter that you came in through the border, right? If you're an SJIS, Special Immigrant Juvenile Status, it doesn't matter. You can adjust your status here. But if you are in a marriage, if it's a marriage case and you came in through the border, you're going to need, and you came in through the border, you went inspected, you went admitted, you're going to need a waiver. All right. So let's talk about what else. Let's talk about, let's see, people who let me see, what else did I have to talk about? Let's see. Let's talk about the waiver process, right? Now, the waiver process means that you have to show that your spouse or your parent, U.S. citizen or green card holder, spouse or parent, will suffer extreme hardship. Now, like I said, there are two types of hardship. There's exceptional, extremely unusual hardship, but that's not what I'm talking about today. I want to talk about the extreme hardship. Extreme hardship is not your regular hardship, like I'm gonna miss my spouse, I'm gonna miss my my parent kind of hardship, right? It's a little more, right? It has to be a little more extreme. So to do that, you have to show that the U.S. citizen or the green card holder is going to suffer because if you're not allowed to stay in the country. And you also have to show that for some reason, the U.S. citizen or green card holder, parent or spouse, will not be able to relocate with you to your country if you're deported. All right. So one of the things that we talk about when we're creating a hardship case is we use the medical situation of the U.S. citizen or green card holder. For instance, you have a parent who lives with you and who's dependent on you to help take care of them. Maybe their medical needs, dependent on you to cook for them, and there's really nobody else that can do it without costing them an exorbitant amount of money, right? Or will that spouse have difficulty adjusting to a new country? Maybe you're from a country that speaks a different language, and your spouse is older and cannot be expected to learn a new language, will not be able to get a job because of their age in the new country, right? Or is your family at risk for maybe are they at risk for being targets of crimes because they came from the United States? Or do you have a child that is, has needs in the United States that your spouse alone cannot handle if they were to stay in the United States, right? Sometimes you can talk of education. Is your spouse, your U.S. citizen or green card holder spouse, in school? And if you were deported, they would have to leave and go with you, and the quality of education in that country is not the same. So these are some of the reasons that you can put together to get to show extreme hardship on your spouse or extreme hardship on your parent. So let's talk about a recent waiver that we got, right? Actually, I'm going to talk about two of them that we got approved. So the first one was a client whose parent is a U.S. citizen. It can be a green card holder as well, but in this case, our client's parents is a U.S. citizen, and she's of a certain age, elderly. That's the parent. So our client's parent filed for her, right? And because our client is on a preference category, which means she is, over 21, for her to be able to get her green card at the time her priority date is reached, she has to be in legal status, and she was not in legal status. So basically, she had to get a waiver for unlawful presence in the United States. Our client had no criminal history, so really all we were waiving was the unlawful presence. And we're able to get the waiver by showing, some of the things that we mentioned. And so the waiver is approved, and now she can go through the next stages, which is going through NVC, National Visa Center, submitting her documents, getting called for an interview. And with the waiver, she will go for the interview. And God willing, she's coming back, with an approved green card. So another situation we had was one of misrepresentation, where my client had applied for B1, B2, indicating that he was married and he was not. So he came in here, like I said, met a U.S. citizen, got married. They have two lovely kids, and then the wife filed for him, and they went for an interview. So the issue wasn't that it was not a bona fide marriage. Clearly it was, but he was inadmissible because of the misrepresentation he had made to the officer when he got a B1, B2 visa, and so of course he was denied, and we had to file him, right? So he came to us when he got the denial, and we were able to put together a strong petition, a strong waiver petition, showing that his spouse, who's a U.S. citizen, and his parent, actually had a parent also here who was a green card holder, suffer extreme hardship if he had to leave and go to the country. One of the things we showed was that his wife was in I think college, I think dentistry school or something, and if he was deported, she would leave with him, and she would not get the same quality of education in the country she was going. And she also had some health issues, which she relied on him to, help her, take care of her. And so when you sometimes the hardship, the health issues could be psychological, issues to anxiety. It could be depression, So as part of filing a waiver, you need a psychological evaluation, a psychological evaluation of the U.S. citizen or green card holder, showing that they would suffer hardship, extreme hardship, if that intending client was not allowed to stay in the United States. And typically, we do a evaluation of both the intending immigrant and the U.S. citizen or green card holder spouse. So I think that's pretty much it. So I'm going to take a couple questions, and if you have questions, put them on. So basically, what I want you guys to take from here, from this waiver conversation, is if you've committed some kind of misrepresentation or fraud, please don't double down by providing fake documents. Talk to a lawyer and let a lawyer evaluate your case to see how a waiver can be filed for you, right? Because doubling down on sending false documents is not the answer. And another thing you need to know, even if you've committed some immigration misrepresentation or fraud, you can still get your green card, okay? Because there's a law that forgives certain, okay? So you just want to make sure that what you've done is something that can be forgiven, all right? And most things can be forgiven apart from, terrorism, if you're part of the Nazi, and some, drugs, aggravated felonies sometimes, so you got to just have a lawyer, evaluate if it's a crime, what you were charged with, to see if, it qualifies as one that can be, a waiver can be filed for. And if you're filing under certain visa types, like a T visa or U visa, that really, it's really forgives a lot. The T visa, the U visa, it forgives a lot. And VAWA is exceptional because with VAWA, you don't have to prove extreme hardship of your spouse or of your parent. You can show only extreme hardship to yourself. That's it. So that's really helpful for people who filed the VAWA application. The VAWA was approved, but the I-485 is denied because of a misrepresentation or fraud. The good thing is you can file a waiver based on just hardship to yourself. And that's an easier waiver to file than showing hardship to a parent or spouse, because some people don't have a parent or spouse who are U.S. citizen or green card holders. Okay. So let's see. So I have some questions here. So Michael Teta says, will you have any form of protection if you have a T visa pending? Well, you don't. I haven't known them to deport anybody who has a T visa pending. So you do have some, if you have a T visa pending, that really is helpful to you. I don't know that there's a name for it, but if you're on T visa, if you now get your T visa, that's definitely a form of protection, because now you have a visa that allows you to stay in the United States for 4 years, and within 3 years you can apply for a green card, unless you are able to show that there's certain circumstances which allow you to get your green card earlier. All right. So once you file a T visa or VAWA, when it's just filed, it's they're not looking to deport you, but you do get a form of protection when you're in T visa status, right? Definitely. When you're on SJIS status, definitely. When you have a VAWA approved, definitely. All right. So Bukola Akano says, my mother filed for my brother and he was told to go back to Nigeria to adjust his status. He doesn't want to go even with the prospect of getting a waiver. Can he adjust here? So Bukola, that's a really great question. So if you listen to my live, that's exactly what it was about. See, unless your brother has another way of adjusting his status here, maybe he married a U.S. citizen, or he has a child who's a U.S. citizen who's over the age of 21, who can file for him, or he has a U visa, T visa, he's U visa, T visa eligible, or one of those humanitarian visas that can allow him to adjust his status here. He's not going to be able to adjust his status based on your mother's petition, because he's in a preference group, and therefore based on that he must be in legal status to be able to adjust his status, and it sounds like he's not. So excuse me. So what I would suggest to you, Bukola, is have your brother call my office. Let's evaluate him for waiver. It's really not that scary. If he qualifies for waiver, he doesn't have to leave until there's an interview pending. So it's not a situation where you're going to go and you're going to be in your country for a long time waiting for an interview. You can stay here. When the interview is, you're called for the interview, you leave with your waiver and you go. It's not as scary as you think. Okay. So I would encourage him to actually get some information on this instead of living in fear, okay? So, so GFV says he had the interview already and refused for administrative processing, but my status stays ready. What does that mean? So GFV, I would need more information, but it sounds to me that you had a consular interview and you probably were refused based on some additional information that they need from you. So, excuse me. So, and they will tell you what that information is. So you should know what it is they need and comply with it. It doesn't mean that it's a denial, right? It just means that there's something that they need from you, So, get on with that. So Elizabeth says, how long should I wait after getting my green card to file for my adult unmarried child who's out of status? So Elizabeth, well, congratulations on getting your green card. You can file for your adult unmarried child right away. However, because your child is on a preference, it's going to take a while before his priority date is reached. And when his priority date is reached, he's not going to be able to adjust his status because he's out of status. Exactly what I've been talking. So he's going to need a waiver. So if you, his mother, you're a green card holder, or even a U.S. citizen at that point, then he might be able to, based on whether you meet certain criteria, a waiver could be available for him so that he can go back to his country and come back through consular process. And that's the way through a parent. However, there are other people who have other pathways. You can have more than one pathways to get a green card. Just because your parent filed for you doesn't mean that that's the only way. You can have different pathways. And so, typically, someone like your son, we want to screen him. We will screen him to see if there's any other thing he could qualify for. I can't tell you how many people, clients who have come to our office, thinking that there was only one way. Maybe their parent had to file for them, and we found that there was another way, which was even a better way, which was a quicker way, a way that maybe they wouldn't need to leave the country. So it might be helpful to talk to an attorney, okay? So Messiah says his EAD expired. He tried to renew, but it's still pending because of a late renewal. Okay. So you received a receipt notice and DMV refused to use it to renew, including prima facie. However, your VAWA has been pending since 2021. So Messiah, every DMV is different. Some DMVs, you don't even need to have a pending case. Like New Jersey, you can be undocumented and you can get a driver's license. So I don't know where you are, but each state has their own rules. So either you move to New Jersey or you find a state that allows you to, you move to a state where you can get a driver's license. But otherwise, you just have to, wait and get your EAD, and you can actually do an expedite request. Try that, okay? So David Manser says, my friend's wife filed her taxes as married, filing separately while she was divorced. Will there be a problem when, I don't even understand this, will there be a problem when he files for citizenship? Well, if they're not married, then I don't know. I'm not really sure I understand the question. It's really not clear. It's really not clear. So let me, because I think what you're saying is, when you file for citizenship, right, as an immigrant, sometimes a lot of times USCIS will go back to look at, whether your marriage was bona fide. Sometimes they do that, and sometimes they don't. So your question is not really clear. So it's really hard for me to really get granular with you when I don't understand. I don't have all the context. So let me go to Instagram and answer a few questions. Let's see. Hi there. Hi, ID Graft. How are you? Oladimeji, nice to see you. And let's see. So Nilechi says, after your VAWA has been approved, how long do you wait before you get your green card? My friend's adjustment of status was filed in October of 2022. Her VAWA was approved April 1st. Nilechi, it really depends, you know. Sometimes it takes 3 months, sometimes it takes 6 months, sometimes it takes 8 months. It depends. We've had VAWAs approved that it took, you know, like 8 months before they called them for a green card, and we've had VAWAs approved that within a couple of months their green cards were approved. I also think it really depends. You know, USCIS, the processing times really, you know, it really depends on the field office, how busy they are, you know. So for some people it might be quicker, and others it won't. But the good news is if the VAWA has been approved, the hardest part of the journey has been completed, in the sense that whatever you're going to wait for is not going to be as long as waiting for the VAWA to be approved. Okay. So all right, it's 4:25, guys. So I'm not gonna be able to stay that much longer because I have something at 4:30. So yeah, so that's pretty much what I wanted to talk about today. And Siobhan says, how can I contact you, Siobhan? You can reach us at 973-993-1900. We're happy to chat with you and see how we can assist you. So that was my talk for today, guys. Such a pleasure reaching out, meeting with you guys again today. And so I come at different times because, you know, work, you know, so whenever I get a minute, I try to get in here. So the best thing to do is to subscribe to my channel and follow me, so that when I come in, you're notified. And if you can't listen to my live, at least you're able to go back to it and listen. And feel free to share this with anybody who you think this might be of, you know, value to them. All right, guys, take care. Bye-bye.